My dear students, good morning, and we will be resuming with our discussion for this day. We will be trying to discuss the relationship between criminology and law and criminology and forensic science. We are done with criminology and sociology last week, criminology and psychology. Those were the topics we have discussed. And my apologies, class. I haven't yet computed your grades because I'm quite disappointed with the result of your examination. Kaya I'm doing my best to see some adjustments. So anyways, I will be sending you your grades as soon as your dean is okay with you. So kita nyo yan, class, ha. Napaka-concern sa inyo ng dean. Ini-strictuhan na before daw i-release yung grades nyo, dapat daw muna dumaan sa kanya. Aba, sobrang concern niya sa inyo. So, dapat lang din na pakitaan nyo ng mabuting ah, kapalit din. Dapat galingan nyo rin yung pag-aaral nyo. Okay? So, part of criminology again, to remind you class, baka nakalimutan nyo dahil dito sa bagyong paing na to, baka nakalimutan nyo, part of criminology is the study of the making of laws, di ba? The study of the breaking of laws and the study of the reaction towards the breaking of laws. And that is now the main point of our topic for today. Found on page 91 of your book, Introduction to Criminology. Please allow me to share my screen. Aha. Ayan. So, criminology and law. What is the difference between criminology and law? So, criminology again is broader, and under its scope is the study of the making of laws. However, uh, the law course or the LLB is now the enhancement. Diba? Parang kung mag-take up kayo ng law course nyo, criminology can be a preparatory course. Pwede rin namang political science. Yan. So, mas angat nga lang ang course na LLB, Law, or Juris Doctor pagka natapos nyo. So, what is law? Law is a body of rules of conduct of binding legal force and effect, prescribed, recognized, and enforced by controlling authority. So there is an authority who controls the implementation of this law. So in our current state of government, in our territory, in our country, Philippines, who are this authority who implements law? So number one would be your PNP, di ba? And when it comes to law on manufacture and sale of illegal drugs, we have again the PNP and the PDEA. And when it comes to the implementation of our environmental laws, we have our DE, uh, DENR, tama, DENR. And when it comes to the implementation of our traffic laws, we have the LTO and the PNP and all other law enforcement agencies. Yan. So marami yan. Hindi lang yung mga yan. Meron din tayong mga army, meron din tayong mga BFP, BGMP, and other NGAs or national government agencies. So these are our law implementing bodies. What is law? It refers to any system of regulations to govern the conduct of the people of a community, society, or nation. So law governs the behavior of a society. Diba? So without law and without authority, there could be chaos. Diba? So kung walang batas at walang mag-implement ng batas, there will be chaos. So we will be having anomy. So what is anomy again? It refers to the breakdown of our social norms to include laws. So pagka wala ng effect yung laws, magkakaroon tayo ng survival of the fittest. So ang tanging matitira na lang is yung talagang malalakas, makapangyarihan. Yan. So law is the highest law in the country is the Philippine Constitution. So what? Baka tanungin sa exam nyo or later on sa board exam, what is the highest law of the land? What is the highest law of the Philippines? It is our Philippine Constitution. So dito lahat nakaangkla yung ating mga iba pang batas such as your revised penal code, your special laws, and your civil laws. So dito lahat nakaangkla, di ba? So specifically Bill of Rights, di ba? Andiyan lahat ng mga rights natin na kung saan kinuha naman at dinevelop pa ng other laws. So laws against illegal searches, di ba? Yung mga laws against illegal searches natin wherein any citizen of the Philippines is protected against illegal searches by the government, di ba? Mga ganyan. So, nakasaad yan sa ating Bill of Rights. So, ano pa ba yung mga nakasaad sa Bill of Rights? Rights to suffrage. Ano ba yung suffrage? Ano bang ibig sabihin ng rights to suffrage? Ito yung rights natin para bumoto at para bumoto at para maiboto kung balak niyong tumakbong politician later on. Right to be voted, right to vote and to be voted upon. Pati yung Miranda rights natin, di ba? Pero yung Miranda case kasi is galing US. So, your right to have a counsel, your right to be provided by a counsel in case you cannot afford to do so, di ba? Kung hindi mo afford ang lawyer, the government shall provide you. So, lahat yan, nakasaad yan sa Bill of Rights natin, Article 3 of your Philippine Constitution, which will be discussed in toto in your Leia yata to, Leia. So, let's move on. How did law evolve? So, paano ba nag-evolve itong law? The earliest law book was written about 21,000 BC for Ur-Nammu, king of Ur, a Middle Eastern city-state. So, ito yung pwedeng tanong to. What is the earliest law book? It is the law book that was written for Ur-Nammu. Ur-Nammu is the king of Ur, a Middle Eastern city-state. And within 3 centuries, we have here Hammurabi. He is the king of Babylonia. He had enumerated laws of private conduct. So meron siyang enumerate na private conduct, business, and legal precedents, of which 282 articles have survived. So here is now the term I for an I, or the equivalent value is found there. As in drowning as punishment for adultery by a wife. So kung yung babae na may asawa noon ay nanlalaki, yan, adultery, di ba? And while the husband could have slave concubines. So meron din namang lalaki na merong concubines. So concubinage din ang kaso niya. And an equal treatment of the rich and poor was codified here first. So it took another 1,000 years before written law codes developed among the Greek city-states, particularly Athens and Israel. So, can you excuse me? Namamaos ako, inom lang akong tubig. Okay? So, it is King Hammurabi of Babylonia who used the term eye for an eye, or in other words, the equivalent. So, kung kamay ang nawala, kamay din ang kabayaran. So, kung putulin yung kamay, di ba? So, kung kamay ang nagnakaw, puputulin yung kamay. China developed similar rules of conduct as did Egypt. So the first law system, which has direct influence on American legal system, was the codification of all classic law ordered by the Roman Emperor Justinian in 528 BC and completed by 534 BC, becoming the law of Roman Empire. So what is the law of the Roman? It is called the Justinian Code. So this is known as the Justinian Code, upon which much of the legal system is most European nations are based to this day. So this law was the basis of European laws. This is the Justinian Code, the law of your Roman Empire. And following the Justinian Code, the principal source of American law is the English common law. So when we say common law again, it was unwritten. So hindi pa siya nakasulat noon, hindi pa siya codified. Kumbaga, tradition pa lang, which had its roots about the same time as Justinian. Among Angles, Britons, and later Saxons in Britain, William the Conqueror arrived in 1066 and combined the best of this Anglo-Saxon with Norman law, which resulted in the English common law, much of which was by custom and precedent rather than by written code. The American colonies followed the English common law with minor variations and the four-volume commentaries on the Laws of England by Sir William Blackstone, completed in 1769, was the legal Bible for all American frontier lawyers and influenced the development of the state codes of law. So what was the basis of your American law? It was the English common law. So English common law muna bago naging American law. The law is the governmental response to society's need for both regularity, consistency, and justice based upon collective human experience. So these laws were created based on collective human experience. So kung may mga sufferings na na-experience yung mga tao noon, ayan, collective human experience, ginagawan nila ng batas para hindi na maulit. Yan. Early Philippine. So we were done with the history of how law was made from the worldwide setting. So we will be going with the Philippine history on how law was created. So before the Code of Kalanchao was promulgated in 1433, the people of pre-Spanish Philippines had customary and unwritten laws. So meron ng unwritten laws ang mga Pilipino bago pa yung Code of Kalanchao, which were only applicable to certain tribes. So depende sa mga tribes and not to all citizens of the country. So yun nga, depende sa tribe, meron siyang kanya-kanyang unwritten law. So, iba yung unwritten law ng Aita, iba yung unwritten law ng mga Cordillerans, iba yung mga unwritten law ng mga lowlanders. Some of the most striking laws promulgated during this period are as follows. First is your due respect to elders and parents. So, ito, sure ako, meron tayo lahat nito, hindi lang sa Cordillera. So, due respect to elders. Yan yung mga unwritten laws natin. Wherein, pagka may problema, there should always be an elder. Or, yan. Ano ba yung meron kasi sa elder? What do they have that the young generations don't have? It is basically on their knowledge gained through experience and experiences of others they have learned. So, basically, experience talaga. So, pagka mas matanda yan, mas maraming experience sa buhay. And, ayan, and they make use that experience of the elders to guide the younger generations. Second is the strict obedience of children to their parents. So, children must strictly obey their parents. Third is the strict fulfillment of contract. So, kung meron tayong naka-contract, meron tayong ano bang contract, meron tayong naka-deal, dapat we have to abide with the terms and conditions of that contract or deal. Otherwise, ngayong araw, ngayong mga panahon, otherwise, pagka hindi mo tinupad yung mga promises mo, estafa, di ba? Estafa yun. Equality of husband and wife, both socially and in the control of their property. So, ito rin. Pagka ang lalaki at babae, meron silang magkaibang antas ng wealth. Yan. Pag kinasal yan, magiging conjugal property, kumbaga yung mga properties nila. And, yun nga, kapag may nangyaring masama, o kaya there comes a time na parang na-realize nila na it's better to have their separate ways rather than nagkasama sila, kaso parati naman sila nag-aaway, mag-split yan. So, pag mag-split yan, magiging ang hatian ng properties nila is equal. Magiging dapat pantay yung division ng properties nila regardless of kung ilan yung naipundar ng isang party bago sila ikinasal. So, after their marriage, yan, dapat equal ang hatian. Kung sakali mang maghiwalay. Kung hindi, di mas okay. Mamanahin pa ng mga anak nila yung mga properties nila. With the promulgation of Code of Palanchao in 1433, so tandaan nyo to when was the Law of Palanchao enacted and promulgated? It was on 1433. The penal law was made severe and extensive. So when you say severe, malala yung penal law. According to the code, the penalties for felonies and other misdemeanor are just some of the following. So this Code of Palanchao created this punishment for felonies. So death, yan ang capital punishment nila nun. Mutilation of fingers. So I believe this was taken or adapted from the Hammurabi law. Mutilation of fingers. Pagka kamay ang nagkasala, fingers na puputulin. Flagellation, incineration, slavery, and being beaten by ants. Yan, so papakagat kayo sa langgam. Slavery, gagawin kayong hard worker. The code likewise provided severe punishment to men who were cruel to their wives. So, meron din tayong early law on vowsy. So, pagka yung lalaki cruel sa kanyang asawa, meron din siyang penalty. Husbands who maltreated innocent wives were sentenced to death. So, wow, death kagad ang penalty niya. Adultery as well as the contracting of marriage to very young girls was severely punished. So, adultery rin is severely punished. We have here the tenets of Kalanchaw Code. So, ye shall not kill. Bawal pumatay. Neither shall ye steal. So, parang nakakala rin sa Ten Commandments natin. Bawal magnakaw. Neither shall he hurt the aged. So, bawal siyang manakit ng mas nakakatanda. Lest ye incur the danger of death. So, bawal ding manakit o magpakita ng injury na nagkukos ng kamatayan. All those who infringe this order shall be condemned. So, lahat ng mga gagawa nito will be condemned. Means to say, i-condemn, pinagbabawal, palalayuin, mapipenalize. Yan. Condemned to death by being drowned with stones in the river or in boiling water. So that's how they do death penalty, by drowning with stones in the river. So tatalihan ng bato yung katawan mo, tatali ka sa bato hanggang sa ma-drown ka, or in boiling water. Wow, mas masakit to. Ye shall obey. So dapat sumunod. Let all obey. Let your debts with headmen be met punctually. So dapat magbayad din ng mga utang. He who does not obey shall receive for the first time 100 lashes. So papaluin ng ilang daang beses, 100 times. Who does not comply with obey and observe this order shall be condemned to swim for 3 hours. So, yung mga hindi naman susunod, palalanguin ng 3 oras for the first time, and for the second time, to be beaten to death with sharp thorns, or for the third time, shall be lacerated with thorns. So, ano ba yung mga thorns? Panusok. So, yung rose, merong thorns, di ba? Yan. So, papaluin kayo ng latigo na may thorns hanggang mamatay kayo. Ay, hindi, hindi kayo. Sorry. Yung, yung mga hindi nag-o-obey. Sorry. So, ye shall obey he who makes exchanges for food. Let it always be done in accordance with his work. So, kung meron naman nagdidil na pagkain, dapat rin nabayaran ng tama. He who does not comply shall be beaten for 1 hour. So, bubugbugin ng 1 oras yung hindi magbabayad ng tama sa mga pagkain. So, he who repeats the offenses shall be exposed for 1 day among ants. So, yan. Ipapakagat ng buong isang araw sa mga langgam. So, ito, tatalian yung kamay, tatalian yung paa, tapos ilalagay sa mga langgam ng isang buong araw. So, slavery of doom, certain period of time, shall be suffered by those who steal away women of the headmen. So, yan, meron din palang ganyan. Yung itatakas nyo yung mga asawa ng heads of tribe. By him who keeps ill-tempered dogs that bite the headman, by him who burns the field of another. So, yan. So, slavery ang punishment. Although shall be beaten for 2 days to sing while traveling by night, kill the bird manaol, clear the documents belonging to the headman, or mock the dead. Yan. So they shall be burned, susunugin. Those who by their strength cunning have mocked at the state punishment, or who kill young boys or steal away women of old men. Mhm. So these were the tenets of the Kalanchow Code. Now we have our Philippine criminal law. So, criminal law or penal law is that branch of law which defines crimes, treats of their nature, and provides for their punishment. Hence, the country has the revised penal code, or what we call RPC. So we have two foundations of your Philippine penal code. The old penal code, which was the old penal code, which is at present known as the RPC, is based on two prominent suppositions, namely classical and positivist theory. So what is again classical theory? It states that what humans are rational thinkers and they have free will. And what about positivist theory? It states that humans or that criminals doesn't have free will and they are not rational. Means to say, they have committed crimes because they were sick. So, nagawa nila yung krimen, nakagawa sila ng krimen dahil may sakit sila. Thus, this criminal shall not be punished. So, dapat daw hindi daw sila ma-punish, but they shall be treated or cured. Dapat magamot. Yan naman ang sabi ni positivist. So, these classical and positivist theories were found in your RPC. So, the following are the principles of classical and positivist theories relative to the code. So, what is the classical viewpoint of penal code? The foremost principle of the penal code is that the basis of criminal liability is human free will. And the purpose of penalty is retribution. So, yung purpose ng penalty is paghiganti ng biktima against the perpetrator. That is the purpose of the penalty. And the basis of criminal liability is human free will. Yan. So, to the classicists and the framers of the old penal code, man was essentially a moral creature with absolutely free will to choose between good and evil, thereby placing more stress upon the effect or result of the felonious act than upon the man, the criminal himself. And so, in short, the classicist states that man acted on their free will. So, they were born a moral creature. So, moral creatures sila. But because of their free will, they can do whatever they want. And they already know what is good from what is bad. They already have discernment. Yan. Thus, they shall be punished if in case they committed crime. And third, uh, they assert that man should only be adjudged and held accountable from wrongful acts so long as free will disappears unimpaired. So long as there's free will, so ang element ng crime noon is free will. So yun ang tinitingnan nila. So did you have free will when you committed that crime? Wala bang ibang kumokontrol sa'yo? May solo ka ba? Voluntarily ka bang gumalaw? Mag-isa mo? Wala bang other causes na nag-cause kaya mo ginawa yung crime? So pagka free will, yan, pagka sarili mong ginawa, mag-isa mong ginawa yung krimen at your own, with your own free will, hindi ka na puwersa, wala kang sakit sa pag-isip, yan, then you shall be adjudged accountable from your wrongful acts. So yan yung tinitingnan noon. It has endeavored to establish mechanical and direct proportion between crime and penalty. So, it has endeavored to establish a mechanical and direct proportion. So, meron na siyang stages. Yung pagkakategorize ng severe punishment to lesser or less grave or less grave punishment. Yan, from severe punishment. So, that's on the classical viewpoint. What about the positivist viewpoint of the penal code? So, first is the classical method considers the offender as an abstract being and of prefixing foreign through a series of hard and fast rules, great multitude of penalties with scant regard to human element. So the positivist principle deviates from the classical school in connection with crime and with the criminal. So the positivist holds that man is subdued. So man is subdued. When you say subdued, saan ba tayo nagsasubdue? Diba? Ah, sa martial arts nyo, ginagamit nyo yung term na subdue. Ano bang ibig sabihin ng subdue? You were locked. Uh, you were subdued. Na talo ka. So parang, in other terms, you were forced. Yan. So subdued occasionally by strange and morbid phenomenon, which constrains a man to do wrong in spite of or contrary to his violation. So yan naman yung tinitingnan ng positivist theory. Were you forced to do that crime? Were you forced to do that thing? Wala bang morbid phenomenon na nag-cause niyan? Hindi ka ba nasaniban? Kaya, kaya mo nagawa yan? Wala ka bang iniindang sakit kaya mo nagawa yan? Wala ka bang sakit sa pag-iisip kaya mo nagawa yan? Kasi kung meron, so exempted ka. Pwede ka mag-exempt from penalty. And third, crime is essentially a social and natural phenomena. And as such, it cannot be treated and checked by the application of abstract principles of law and jurisprudence, nor by the imposition of a punishment fixed and determined a priori, but rather through the enforcement of individual measures in each particular case after a thorough personal and individual examination conducted by a competent body of psychiatrists and social scientists. Yan. So, pagka mostly yung perpetrator natin is meron daw sakit sa pag-iisip, it will be examined or he will be examined by a competent body of psychiatrists, those persons who are expert in studying human behavior and the way they think, and also social scientists. So ano ba itong mga social scientists na sinasabi na to? Diba sa mga Facebook, marami kayong mga nakikitang social experiment, mga ganyan. So that's a part of your social scientist. If one person was given this, ano kaya ang gagawin niya, di ba? Yan, isang example ng social science. Inaaral nyo kung ano kaya yung maging reaction ng community given a certain scenario, given a certain chance or opportunity. Yan. So we now move on with the characteristics of criminal law. So this is just to give you a background because this will be discussed on your law thoroughly. Discussed on your law. So first characteristics of our criminal law is generality. Generality of criminal law provides that criminal law is binding on all persons who live or sojourn in the Philippine territory. So, means to say walang exempted. When we say generality, lahat ng tao, yan, na nasa Pilipinas, yan, are not exempted from the implementation of the law. So, walang excuse. Maski sino ka, so long as nasa Philippine territory ka, pagka gumawa ka ng krimen, mag-i-effect sa yung batas. Yan. Generality. So, it is binding on all persons who live or sojourn in the Philippine territory. So, maski foreigner ka, basta nasa Pilipinas ka, gumawa ka ng krimen, yan, hindi ka exempted. You will be prosecuted, di ba? Second is territoriality. So what is territoriality? Territoriality of criminal law states that criminal law undertakes to punish crimes committed in the Philippine territory with the exception provided under Article 2 of your revised penal code. So when you say territoriality, the basis of the implementation of law is the area itself. So we have to determine the boundary of Philippine territory. Yan. As stated under Article 2 of your RPC. So, anong ilang kilometers from the shore? Yan. So, dapat alamin natin. So, pagka yung krimen nangyari within the Philippine territory as described by your Article 2, then it shall be prosecuted by the Philippine law. Yan naman ang territoriality. So, when you say territoriality, the basis of your criminal law is on the territory itself. So, dapat nasa Philippine territory yan. And prospectivity. Prospectivity concept of criminal law provides that it cannot make an act punishable in a manner in which it was not punishable when committed. So, it is talking about the ex post facto law. Thus, crimes are punished under the laws enforced at the time of their commission. So, when you say prospectivity, yan, pagka, kunwari, gumawa ka ng krimen, pero ay gumawa ka ng kasalanan, pero hindi pa pinagbabawal ng batas o wala pang batas na nagawa yung Senado at inapruban ng President, so wala pang batas na nagbabawal sa ginawa mong yon, hindi ka pwedeng makulong. Kumbaga yan, prospectivity. So, kung meron ka mang kasalanan, dapat nakabase sa already existing law. So, means to say, pagka, ano ba yung mga batas natin yun? O, so, sabihin na natin, for example, yung yung VAUC, diba? Nung hindi pa na-implement yung VAUC, let's say, for example, sabihin na natin, 1980s, yan, kasi 2000s lang yung mga yan eh. Year 2000. So, let's say, for example, 1980, meron kang girlfriend, pinagsasampal mo. Tapos, ngayon, nagawa yung VAUC. Ngayon, nireklamo ka ng girlfriend mo noong 1980 ng VAUC, Violation of Violence Against Women and Their Children. Kasi pinagsasampal mo siya noong taong 1980. 2000 lang nagawa yung batas. Mag-i-effect ba yung batas sa'yo? Hindi. Kasi nauna yung act na ginawa mo prior the implementation of the law. So, yan ang prospectivity. Dapat when you say prospectivity, mag-i-effect lang yung law the day the law was implemented onwards. So, kung ngayon nagawa yung law, tapos na-violate mo yung law, so naunang na-implement yung law bago mo na-violate, then you have to suffer the consequences. Pero, kung matagal mo nang nagawa yung krimen, tapos ngayon lang ginawan ng batas na krimen pala yung nagawa mo noon, hindi siya pwedeng magkaroon ng retroactive effect. So, when we say retroactive effect, ito yung kabaliktaran ni ex post facto law. So, hindi ka pwedeng ma-penalize, hindi pwedeng mag-effect yung batas pabaliktad. Kumbaga, panakaraan. Kumbaga ganyan. So, hindi pwede ang retroactive effect. Wala siyang retroactive effect. Kumbaga, hindi siya mag-effect before the implementation of the law. So, dapat mag-effect yung law after the implementation of the law. Kaya nga, ex post facto law. So, when you say post, dapat tapos na. Di ba? Post. Hindi siya pre. Ex post facto law. Hindi siya ex pre. So, the principle of legality. So, the principle which declares that for any human conduct to be considered as a criminal act, there must be a specific statute or law declaring such conduct as a crime and providing for a penalty. So, nolum crimen, nolum pena sine lege. Means to say, if there's no law punishing it, then it cannot be considered as a crime. Any human conduct, no matter how evil or reprehensible it may be, cannot be subject the actor to punishment if there is no law punishing the act. This is expressed in the maxim, yan, nullum crimen, nulla pena, sine lege. Yan. So, hindi ka pwedeng mapunish kung walang batas na nagsasaad na krimen yung ginawa mo. So, this principle is the opposite of common law crimes. So, magkaiba yung written laws sa ating common law crimes. So, when we say common law crimes again, mostly these are based on unwritten laws or unwritten tradition of crimes. So, common law crimes are often called court-declared or created crimes. Mhm. So, this principle is the opposite of common law crimes. Common law crimes are often called court-declared or created crimes. So, yan nga. So, kung meron tayong judge noon, tapos ano ba yung ginawa nito? Kumbaga, kinuha niya yung salapi ni Don Pedro habang nakatalikod si Don Pedro at tumakbo. So, yun ang kwento. Ngayon, yung judge natin noong araw, siya ang mag-iisip. Crime ba to o hindi? Crime yan. So, yan. So, ano kayang, siya na rin ang mag-decide. Ano kayang penalty nito? Kamatayan. So, yan ang ibig niya sabihin. So, it is the court who makes or who judges the act whether it is a crime or not. And it is the judge who decides the extent of punishment. Unlike nowadays, unlike nowadays, meron na tayo mga batas na nakasulat sa RPC and other special laws, di ba? And also, nakasaad na rin doon yung mga punishment niya. So, hindi na kailangang pag-decidean pa ng judge kung crime ba yan o hindi. Kasi nakalagay na sa batas eh. Yan. So, ang gagawin na lang ng ating mga judges nowadays is yan, to determine whether or not the prosecution is telling the truth and at the same time whether or not the defense is also telling the truth. So, yun na lang ang gagawin ngayon ng judge. Unlike noon, yan, pati yung krimen, didetermine niya kung krimen ba o hindi, at saka i-determine niya ba kung punishable ba o hindi. So, we have here Latin maxims. Sorry, nabubulol ako. So, accessories sequitur. pertains to one who is an accessory to the crime cannot be guilty of a more serious crime than the principal offender. So yan, pagka-accessory ka sa krimen, hindi pwedeng mas mabigat yung penalty mo kaysa sa principal offender. So ano ba yung principal, sino ba tong principal offender? So siya yung main actor ng krimen. Eh, ano ba yung mga accessories naman na sinasabi? These are mostly na participation ng accessories, sila yung mga lookout, di ba? So, mag-serve ka as lookout habang gagawin ko tong krimen. Pag nanakaw ako, mag-serve ka as lookout. Pagka may pulis na paparating, sinyalan mo ako para makatakas tayo ng mas maaga. Mga ganyan, di ba? So, yan, lookout. Pag nag-lookout, yung isang tao, accessory na yan. So, sino naman, ano naman yung participation ngayon nung nagnakaw? Siya yung principal offender. Second is acta extoriara iudicant interiora secreta. So, outward acts indicate the inward intent. So, kung ano yung ginawa mo, it shows your intention. So, yan. Actori incumbit onus probandi. So, the burden of proof lies on the plaintiff. This is very true. In criminal case again, ilang beses na natin ito nasabi, what is the quantum of evidence required in criminal case? Proof beyond reasonable doubt, diba? And the burden of proof to prove that reasonable doubt in court lies on the prosecutor and the complainant. Yan. So, actus non facit reum nisi mens sit rea. So, the act does not make one guilty unless there be criminal intent. So, mens rea, mens sit rea. Yan ang criminal intent. So, the act does not make one guilty unless there be criminal intent. So, in all our laws, in what law can we observe that intent is an element of the crime? It is your RPC, di ba? So, sa ating revised penal code, intent to commit crime is an element. So, theft. Asan yung intent doon? It is the taking of a property belonging to the other person without the consent of that owner and with the intent to gain. So, yun yung intent niya. Intent to gain. Actus reus, a guilty deed or act. So, you say actus reus, it shows a guilty deed or act. Amicus curiae, a friend of the court. So, amicus curiae. Who are the friend of our court? We have here lawyers, law enforcers, yan. Animo furandi, with an intention of stealing. So he has the intention of stealing. Corpus delicti. So corpus delicti pertains to the body of the crime. So it does not necessarily mean that if the case is murder, tapos ang sabi ng judge, bring the body of the crime, yung cadaver ang dadalhin nyo. Diba? So pwede namang picture at saka death certificate ng biktima. Damnum sine injuria. So damage without legal injury. Doli incapax, incapable of crime. So, yung mga may kapansanan, incapable of crime. Dormiunt legis aliquando, nunquam morion tur. So, the laws sometimes sleep, but it never dies. Yan. So, in what way does the law sleep? Walang nakakita, di ba? But it never dies. The law is still there. It is still in effect. Ex post facto law. So, yan, nag-discuss na natin to. By reason of a subsequent act. So, means to say, ex post facto law. So, the law was already enacted, ginawa mo, tapos it was written in that law that you have violated that law, then, yan, the law shall effect on you. Habeas corpus, that you have the body. So, you have the evidence. Habeas corpus. Ignorantia facti excusat. Ignorantia juris non excusat. So, ignorance of the fact excuses. Ignorance of law does not excuse. So, yan. So, ignorance of the fact excuses. But ignorance of the law does not excuse. So, kahit na hindi mo alam yung batas, pagka binayolate mo, the law exempts no one. Pero, kung yung hindi mo alam is yung kwento, pwede kang ma-excuse. Diba? Ignorance of the fact excuses, but ignorance of the law does not excuse. In delicto, at fault. So, you are in delicto. Who's the party in delicto? So, sino yung party at fault? Injuria non excusat injuriam. A wrong does not excuse a wrong. So, sa court, di ba? Nag-swear ka under oath. Magsasabi ka ng katotohanan. Tapos, ayaw mo makonvict. Kaya nagsinungaling ka. So, a wrong does not excuse a wrong. Hindi pwedeng ma-excuse ka from liability because you have lied. Actually, madadagdagan pa nga eh. Madadagdagan pa yung kaso mo ng perjury. Kasi you lied under oath. So, lex prospicit, not respisit. So, the law looks forward, not backward. So, it is in relation with your ex post facto law. So, the law looks forward, not backward. So, pagka may batas na in-implement, mag-i-effect siya forward. Hindi siya mag-i-effect backwards. Not unless, the exemption is not unless it is favorable to the accused. Yan. So, pagka favorable siya sa accused, then it can effect backwards. So, ganito yung kwento ni Rowin Padilla eh. Na-lessen yung penalty, kaya nag-effect sa kanya. Nung nahuli siya under illegal possession of firearms, di ba? Mala fide. So, in bad faith. Mala fide. Mala in se. Bad in themselves. So, what are your crimes mala in se? These are violations of your revised penal code. They are bad in themselves. Mala prohibita. Crimes prohibited. So, what are your crimes prohibited? Your mala prohibita? These are crimes in violation of the special laws. Malo animo. So, with evil intent. Malo animo. Mens rea, guilty state of mind or intent. bad intent, mens rea. Nemo bis punitur pro iudem delicto. So no one can be twice punished for the same offense. So in English, double jeopardy. Bawal siyang ma-endanger twice for single offense. Post-mortem. When you say post-mortem, after death. Kaya post-mortem examination, examination of the cadaver after his death. Yeah. Prima facie. So prima facie means on the face of it. So I have the prima facie proof. So meron akong ebidensya. Yeah. Voluntas and delictis non exitus spectatur. In offenses, the intent and not the result is looked at. So dapat yung intent daw ang tinitingnan and not the result. So kung wala siyang intent to commit crime, pero the act resulted in a crime, then he could be, then that person could be exempted from criminal liability and from punishment. So that's all about your criminal law in relation to criminology. So we will be also discussing your next subject, criminology and forensic science. So let's have a 10 minutes break.